Hello everyone, my name is Geetanjali Singh and I am currently interning at LEXIS and Company, and the topic for today's video is Navtej Singh Johar versus Union of India, which is a landmark judgment that struck down the constitutional validity of Section 377. Now this was a writ petition of the case of earlier, which was it was the writ petition of the case of Suresh Kumar Kaushal versus Nas Foundation, saying that the matter and decision be left upon the Parliament, and the section of 377 was rejected in 2015. Now the writ petition, now this case was as followed. The facts of the cases are: there were total 5 judge benches of Chief Justice, wherein the Chief Justice was our Honorable Deepak Mishra, and the key facts for this cases were: Section 377 criminalized consensual sex intercourse between persons of the same sex for being against the order of nature. Now, in 2009, before the Delhi High Court, the case of Nas Foundation Trust challenged the constitutionality of 377 for violating Article of 14, violating our fundamental right, 14, right to equality, 15, 19, 21 of the Constitution. The court ruled that punishing sexual activity between two consenting adults under 377 violates the right of equality, privacy, and personal liberty of such persons. Now there were 5 individuals from LGBT community: Navtej Singh Johar, Two Dalmia, Aisha Kapoor, Amarnath, and Sunil Mehra, who filed a new writ petition challenging the constitutionality of Section 377. The facts of the cases are: they were the dancer from LGBT community, and it was pleaded, and the petition prayed for the declaration of right to sexuality, right to sexual autonomy, and right to choose our sexual partner to be the part of right to life guaranteed by Article 21 of under the Constitution of India. It was also prayed by the petitioner to declare 377 as unconstitutional. Now the issues of the cases were: the Article 14 as it discriminate against individual on the basis of sexual orientation and gender identity, whether the right of autonomy and dignity under Article 21 by penalizing private consensual acts between the same-sex groups, and whether the right of expression under Article 19 subclause 1 part A by criminalizing the gender expression LGBTQ plus community is valid or not. Now the decision which was taken by High Court in Kaushal, all the 5 judges in this case, all the 5 judges overruled the Kaushal case, where the court drew on the doctrine of progressive realization of the rights that holds should not be revoked. The march of progressive society should only be for. The court also noted that the guarantee of a fundamental right to privacy in the case of Justice K. Puttaswamy versus Union of India, and held that Kaushal's finding that Section 377 not only affected a minuscule minority but also disturbs the Janta as a whole. Now, it cannot be basis to deny the right of privacy. It is observed that minorities face discrimination because their views and beliefs do not align with the majority, and the Kaushal decision violated the right of all the persons that was equal of protection. Now, there was a litmus test for survival of Section 77, and the Supreme Court tested the constitutionality against the principle of equity, liberty, and dignity under Section 14, 19, and 21. Now, the right of equality and non-discrimination in this court observed that Section 377 arbitrarily punishes individuals who engage in same-sex relationship. To substantiate this, the court noted that 377 classifies and punishes individuals who engage in carnal intercourse against the order of nature and to protect women and children. However, this objective has no reasonable nexus with the classification, and the court held that this violates Article 14, which is the very basis of non-discrimination. Now, freedom of expression was also being discussed, and the court acknowledged that all persons, including LGBTQI individuals, had the right to express their choice without any fear. It has been recognized that same-sex sexuality as a normal variant of human sexuality. In particular, the court noted that Section 77 stigmatizes and discriminates against transgender persons. Now, in this case, an unreasonable restrictions on act within a person's private space will have chilling effect on the freedom of choice for these reasons. And the court held that 377 is disproportionate and violates the fundamental right to freedom of expression. Now, right to life and personal liberty was also being discussed, where the court held that Section 377 violates human dignity and decisional autonomy and the fundamental right of privacy. Every individual have the liberty to choose their sexual orientation, seek companionship, and exercise it within their private space. As Section 377 inhibits the exercise of personal liberty to engage in voluntary sexual acts, it violates Article 21. Denying the right to determine one's sexual orientation curtails the right to privacy of an individual, and therefore the court held that the scope of right to privacy must be widened to incorporate and protect sexual privacy. Now, the order of nature, where Section 377 criminalizes unnatural sex, which is against the order of nature. The court held that such a classification between natural and unnatural intercourse is not legally valid. Naturalness should not determine the validity, legality, or acceptance of a phenomena, and penal consequences for an act that is unnatural or wrong cannot be imposed without sufficient justification. The constitutional morality was also being discussed by the Honorable High Court, where the court described that as the ideals and morals of constitution and the values that create an inclusive society. It recognized the constitution as a tool to transform society. A decision on whether a penal provision violates fundamental rights must be guided by principles of constitutional morality and not only societal morality. What people think does not have to make an impression upon what people want, where a constitutional court might finds that provision violates constitutional morality and it must be struck down. All the arguments that has been raised by the respondents, like Section 377 of IPC does not violate Article 14 of the Constitution, as it merely defines a particular offence and its punishment, and Article 377 of IPC does not violate Article 15, and person indulging in unnatural and sexual acts made punishable under 377 are more susceptible and vulnerable to HIV and AIDS, and right to privacy cannot be extended to enable people to indulge in unnatural offence, thereby contracting HIV and AIDS. It was also been argued that decriminalization of Section 377 of IPC will shamble the family system and determinedly affect the institution of marriage, open a floodgate of social issues which the legislative domain is not capable of accommodating, and would also have a cascading effects on the existing law. It was also incorporated that after taking a note legal system and principles which prevailed in ancient India, and the said section is relevant legally, medically, morally, and constitutionally in the present situation. These all baseless arguments were struck down by the Honorable Supreme Court by declaring the Section 377 of IPC unconstitutional. Now, to conclude this case, we must say that the court upheld the right to equal citizenship of all members of LGBTQ community in India. Thus, it is read down that Section 377 to exclude consensual sexual relationship between adults, whether between same-sex individuals or otherwise. Section 377 will continue to apply to non-consensual sexual activity against any adult sexual acts against minors and bestiality.